Do you find yourself thinking that that was a horrible case? It was decided as much in the court of public opinion as it was in the actual courts.
Oh, no question about that.
And it would be even worse now because there are people taking to Twitter, for example, and releasing all manner of opinions on the internet, making it possibly much harder even than it was at the time for a person like yourself to preside over such a case.
I hold the media, I got to say, in very low regard in the reporting of these sorts of cases. I think that now take this fellow at the moment, whatever his name is, a politician who's supposed to have rorted the health services unions finances and paid for prostitutes and other. Now, so far as I am aware, he's never been charged with anything. He may be as guilty as hell, but he's never been charged with anything. There's never been any finding which has been published that he's done anything wrong. But if you were him walking through a door of the court today to answer a charge, you'd be saying to yourself, look, I'm hung and drawn before I walk through the door. I'm regarded as being that sort of person. Now, I just think that I have absolutely no views about that matter. But it doesn't look too good. And I think the situation still is in England that the media can only report the fact that somebody's been charged with an offence. I think the media, this could be wrong, but it used to be the case, they couldn't report the proceedings of the committal proceedings, which of course is, which you only hear from the Crown, and if it's widely publicised, by the time the trial starts, you'd have to say to yourself, well, some cases, the jury's probably read this stuff, and because not every juryman or woman is got the analytical mind of a lawyer. So,
given that it's a bit of a shutting the stable door after the horse has bolted type of problem, nevertheless, and in light of all your experience as a judge and in a number of different jurisdictions, and the fact that you've done many, many arbitrations and you've worked a lot internationally, you've even had the opportunity to see different legal systems to ours and maybe to compare and contrast as well while you've been doing all of this. I just wondered, we can't do much about the fact that information gets out there, I suppose, but you said a moment ago about people trying to bring a more analytical approach. Is there still an opportunity somehow to educate people, at least as far as, okay, there may be some so-called facts out there, however, you can still go about your work as a jury, for example, properly, because there are all these elements to consider?
I think, yes, and I'm speaking really now from a lack of real knowledge because, firstly, I was not a criminal judge, and I'm out of the swim now, but I think judges do a pretty good job in telling the jury first up that all they should do is listen to what's said in court and the evidence. And I still have a lot of faith in the jury system, as many people much more experienced than I have in the field, that in the vast majority of cases anyway, jurors do have the ability, certainly the willingness, but the ability to heed what the judge says and only decide the case on the evidence and what's put to them in court. I'd like to think that. I've thought a bit about our legal system. There is no doubt, I've seen how it operates elsewhere and in Europe. There is no doubt, and this is always talked about, it's very expensive, which is terribly unfortunate. And I think in commercial cases it might have become too expensive, but I still think that our system is the best for arriving at the correct decision.
More so than, say, the inquisitorial system they use in France?
Yes, I think so. But, of course, if you say that, you have to live with the cost. And for instance, when I was working in Europe with European arbitrators and with a set of, well, actually two sets of English counsel, really, they couldn't understand, my two co-arbitrators, one particular, couldn't understand why the lawyers would go to such lengths to try and prove their case. But that's what lawyers were trained to do. Their clients could afford to do it, and it's the best way to try and arrive at the correct result. But it is a one. You know, if you're a mother of a child who's disabled, and you go to a lawyer and he says, look, they don't say it these days because they take the risk, but I mean, it's going to cost you $100,000 to run this case. That's what our legal system involves. Well, then that's a big discount. But having said that, I still have retained my confidence in our system. I know Tom Bathurst and every other judge gets up time and time again and says we've got to reduce costs, and there is room for that, I know. But I don't know of any system which is more likely to arrive at the correct result, criminal or civil.
You say there's room for reducing costs. Do you mean through avenues such as ADR, for example, or are you thinking even more broadly than that?
I always tell parties to mediations that they should regard the exercise as an educational one. They're there to find out how big the risks are for them. They've got a case, they can settle it or they cannot settle it. Whether they will settle will depend upon their view, whether they've got a 10% or a 90% chance of success or whatever. And there's no better way to find out how big that risk is than engaging in a frank discussion about the risks. So, sorry, I've rather lost my own track, but...
I was just asking about reducing the cost overall and the alternate routes.
That's I think, as effective a way of reducing costs. I must say, if a mediation does not succeed, it's my experience that it doesn't seem to reduce the cost of the case in court. I've been mediator in some cases which have not settled, because the labourers across the road where the case has gone for 6 or 9 months, every issue fought, and the mediation really hasn't, because it's failed, hasn't reduced the issues. I think there's perhaps...
Is that the fault, though, of the lawyers involved, or is it more that the opposing parties, their source of their grievance is so intractable they just couldn't budge?
Well, a good question. You see, a lawyer is retained by his client to win the case, to take every point which is arguable. And he might take 6 points and only succeed on 2. It's asking too much of him to abandon the other 4, unless his client says, well, look, on advice, well, look, let's only run the defence on, or the claim on 2 points. So I'm, given our system, I'm not critical of And the fact is that in any case, the client's instructions are, I want to win this case.
I want a barracuda to win for me.
That's right. And if there are 100,000 documents involved in a commercial case, he doesn't want his lawyer not to look at them, in case he turns up something which is helpful to his case. People talk about... I never really, in my time at the bar, was confronted with this huge problem that now seems to attend most commercial litigation about discovery, which takes a huge amount of time and money.